SB1389 today. I'm going to say from the offset, there are some negotiations going on right now. So what this bill looks like right now is probably going to change, but the overall concept is not. And that the purpose of the bill is to raise the compensation of the circuit clerks, and that we still want to do. But the bill as written would change it from a salary schedule to an amount equal to 62% of the annual salary of an associate circuit judge, and it would allow their salaries to change as the circuit judges changes as well. They hit a little bit of a snag over in the House, and I think they're going to work through that. I think they actually may have it up on the floor today, so we may have to change back to some type of salary schedule, but I don't expect it to look exactly like this, but the overall purpose is to raise their compensation, so that part will not change. I'm happy to answer any questions.
We will begin with those in support of the bill. First witness come forward in support. Make sure you state your name and fill out a witness form, please. How many do we have testifying in support?
Only 4, and we'll be
Okay,
fast.
thank you. Okay.
Promise.
Madam Chair, I've already checked. I said, you're not all going to testify, are you? And they said no.
Okay, thank you. Just had to ask. You may begin, ma'am.
Okay. My name is Tiffany Phillips, and I'm the circuit clerk in Polk County in Bolivar. I'd just like to thank you for your time today and letting us all be here. I'm here to talk about the way the job of the circuit clerk has evolved since the last revision of Chapter 483.083 in 1995. Yes, you heard that right, 29 years ago since there's been a pay increase. The circuit clerk's office is in charge of the following, just to name a few: probate court, associate and circuit civil court, family court, criminal court, municipal courts. I currently have 6 municipal courts in my little county. Juvenile court, probation cases, adult drug court, mental health court, DWI court, criminal non-support court, domestic violence court, veterans court, child support initiation, vital records reporting, grand juries, jury trials, office budgets, court reporting. Only the circuit judges have court reporters. We are the court reporters for the court. HR for all employees within our office, records and record retention, redaction of all personal information to the public, and accounting for all filing fees, fines, bonds, court cost, interest funds, service fees, law library, the list goes on and on. While it isn't new, I felt it worth mentioning. Supreme Court Rule 4501 states the courts are always open for certain purposes. This can make things real fun. Because of this rule, we're on call 24/7 for emergency filings such as search warrants, 24-hour holds, ex parte orders, 96-hour mental health orders. It's not uncommon for me to get a call while having dinner or while I'm sound asleep to come to the office, at least log onto a computer to process some sort of time-sensitive paperwork that cannot wait till office hours. When I started this job in 2003, we had a staff of 6 clerks. I now have a staff of 12 to manage. Double the staff, double the workload with no additional compensation. I've been through multiple computer programs throughout the years. We currently navigate through 6 different computer programs in the court on a daily basis. We're taxed with the responsibility of managing and troubleshooting court technology with no IT training or little assistance, and most of us didn't grow up in the IT world, nor did our judges. I asked Eric five other ways to make payments. This can be a accounting nightmare. It's more than receipting and dispersing. It's also reconciling all forms of payments to the bank, relying on systems to communicate with each other, which often fail. The process of reconciliation has become a process in which any other business would require a professional accountant. We are the professional accountants in our office. The most recent change, and some would argue one of the most impactful, was the passing of Amendment 3. This amendment requires us to automatically expunge thousands of cases within the required timeframes for specific categories that we, clerks, are required to identify. I'll be happy to answer any questions you have on this, but I'm guessing you're well aware of the headache that Amendment 3 has caused. We circuit clerks are the administrators, CEOs of the court. We are the managers, HR, accountants, IT specialists, event planners, coordinating venues for trials out of our courthouses, especially with the COVID we've had. Public relations specialists, communicating with the public, answering questions, developing, documenting, allocating information. If there's a problem, we're the fixers of those problems. Like you, we have a responsibility to our communities and the voters that put our trust in us to do the job and do it well. It doesn't matter if you're in a small office performing these duties yourself or a large office overseeing every project and making sure it's done correctly. We need to have the best people in these positions, and our best people are not being compensated. During 2019-22 term of office, 10 circuit clerks left the office prior to the end of their term. In 2022, 28 circuit clerks did not seek re-election. Lack of adequate compensation for the rapidly increasing workload and required duties of the circuit clerks was cited as the primary reason. It's been since 1995, and we just think it's time for a change. I'll be happy to answer any questions that you might have.
All I can say is wow. And it sounds like it could be time. Any questions from the Senator Koenig?
Maybe this has been answered, I'm not sure. How much does an associate circuit judge make?
Right now, it's 156,000 and some change.
And if I can just put something in here, I mentioned before you got here that we may very well go away from this wording and go more to a different salary schedule. So I'm not sure this is going to be the final. We ran into some headwinds in the House, and so we're working on that. So this is likely going to change with how the salary is done, but the bottom line is we do want to do a salary increase.
Any other questions from the committee? Seeing none, thank you, ma'am.
Should I just leave this here?
We're going to, I think we have a quorum. Yeah, 1, 2, yes. Madam Secretary, would you please call the roll?
Senator Gannon,
Here.
Senator Crawford,
Here.
Senator Carter, Senator Coleman, Senator Koenig, Senator Rizzo, Senator Washington.
We have a quorum, and we will continue with Senate Bill 1389. Next in support. State your name, please.
Good afternoon, ma'am. My name is Eric Stallo. I'm the Sheridan County Circuit Clerk and Recorder of Deeds. I have been in that position for 18 years now, and I'd like to go through some things with you, some topics there to help clarify or help hopefully get your guys' support. Since 2018, there has been a steady increase of all case types filed in courts across the state of Missouri. The overall increase from 2018 to 2022 for all cases filed statewide has been an increase of 8%. However, in just case type of traffic and ordinance cases, the increase is a staggering 84% through that same time frame. One of our biggest responsibilities is to collect fine money, court costs, filing fees, and other miscellaneous fees, and to distribute this money to the various entities across the state of Missouri, including the state. The money we collect is distributed once a month, and we have to reconcile our accounts weekly, if not daily, in order to get them to reconcile. And unfortunately, like Tiffany said, we are not accountants. The circuit clerks statewide have collected and distributed over $200 million in 2022, and these funds were distributed to the municipalities, the counties, and to the state. Over the past 5 years, we have distributed an average of over $24 million back to the state each year. This is a huge responsibility for each circuit clerk, yet day in and day out we collect and we distribute these funds timely and to the correct entity. Our request is fairly simple. We would like each circuit clerk, regardless of the classification of their county, to make the same salary. Each circuit clerk statewide takes on a very similar role, and our duties are very closely aligned from county to county. Our request is asking for approximately $4 million. Asking this amount will allow us not to have to come back in the future for a statutory salary increase. In my 18 years of being a circuit clerk, I have received an average salary increase due to COLAs of approximately 1.8% each year. All of these increases have spilled over, and the added stress to the circuit clerk and their staff to figure out new ways to become more efficient. To add to the stress, we are required to have our dispositions of each criminal case entered into the system within 7 business days due to the Missouri Department of Revenue and their federal dollars that are tied to our record convictions. As we all know, there's only so many hours in a day that we can work to accomplish these daunting tasks. So today I would ask each for your support for this bill in order to allow the accurate salary compensation that comes with the specific duties and responsibilities of the circuit clerk. Thank you.
Questions for the witness in support? Seeing none, opposed to the bill? Any witnesses? Seeing none, informational purposes only. Okay, in support. Did I miss that? I'm sorry. I thought it looked like you wanted to get up.
In ever so lame way.
Yeah.
Good afternoon, Senator. Good afternoon, Senators. I appreciate the opportunity to testify on behalf of Senator Crawford's legislation today. I'm David Claridge, today appearing on behalf of the Missouri Circuit Judges Association and the Missouri Court Reporters Association. We're proud of the relationship that we have with the men and women who are our clerks. They serve an extraordinarily valuable function in the courthouses, and we want to make sure that they are incentivized not only to stay, but to be able to find replacements in the future. So I want to just go on record on behalf of both associations on their behalf.
Thank you. Any comments from the committee? Seeing none. Thank you. Next in support.
Good afternoon. My name is Susan Sadler. I'm the circuit clerk in Pettis County. I've been the circuit clerk for almost 18 years. Prior to that, I served as a deputy clerk in the office for more than 20 years. So I've served Pettis County and the state of Missouri for a total of over 37 years. The compensation for circuit clerks in Missouri is currently set according to county classification. In 1995, when Chapter 483.083 was last changed, the salaries in the statute ranged from a little over $27,000 up to $36,000. That's less than what the deputy clerks in our offices are making around this time. Obviously, we've benefited from COLA increases during the past 29 years, but there's been no change in the base pay. And over time, as we all know, COLA increases also create more disparity between the different salaries. As we've heard from my colleagues, much has changed in the circuit clerk's office during this time, and the salary structure is no longer equitable. As we all know, the classification of a county is based on the assessed valuation of that county. That may have little relationship to the population of a county, and it is certainly not an indication of the caseload handled by the courts in those counties. The judiciary uses a clerical weighted workload study, which is a reliable process of gathering statistical information from courts to determine the amount of work processed in each Missouri county. That information is used to determine the total FTE, full-time equivalent, that will be authorized for each county by the Circuit Court Budget Committee, whose members are appointed by the Missouri Supreme Court. Using the list of authorized FTE for each county, we are able to compare several counties with a similar workload, but vastly differing salaries among those circuit clerks. My county, Pettis, is a fourth-class county operating as a second-class county. Our authorized FTE is 16.64. My salary is about $78,000. Camden County is a first-class county whose authorized FTE is 15.45. The circuit clerk's salary in that county is about $86,000. Phelps County and Pulaski County are both third-class counties. The authorized FTE in those two counties is 18.22, 17.45 respectively. Those circuit clerks earn a salary of $68,000. So by making these comparisons, we can see that using county classification to determine the salary of circuit clerks, particularly given the fact that circuit clerks are paid by the state and not by the county, does not make much sense. Circuit clerks throughout the state in every county classification agree that every clerk should earn the same pay. While the duties performed on a daily basis differ greatly based on the size of the counties or the size of the courts, the work we are each responsible for is exactly the same. whether our time is primarily spent managing staff and caseload, or whether we are processing the cases and working in court, we are responsible for getting the work of the courts done. We appreciate your time today. Thank you very much, and I'll be happy to answer any questions.
Any questions from the committee? Seeing none, thank you. Next in support. Next witness in support.
My name is Brian Feemster, and I am the Circuit Clerk of Greene County, Missouri. I've just completed my first year on the job, and my previous career was in the electrical generation and supply industry with City Utilities of Springfield, Missouri. My experience in those jobs was anywhere from a mechanic to the director of power supply. I got to see it from a lot of different angles. So there are similarities between power generation and the circuit clerk's responsibilities. One of those is both produce a product that fulfills critical needs of people. Both require skilled, capable people with a great work ethic and willingness to work together. Both depend on a myriad of procedures which must be used to achieve excellent results. Both utilize multiple computer software systems. Both must quickly and effectively adapt to changes in statutes, rules, and regulations. And both require interaction with the news media. However, circuit clerks have responsibilities that we did not have in power generation. We work as circuit clerks with our customers face-to-face and on the phone. We're responsible for accounting for the funds into and out of the courts. We bridge the differences between state court rules and individual needs of courts and judges. We take care of most human resources functions. We work with law enforcement, prosecuting attorneys, and pro se litigants. We work with multiple advocacy groups for the benefit of our customers. My transition to circuit clerk has been accelerated by the knowledge of experienced managers and clerks in Greene County, and just as importantly, the wide spectrum of knowledge readily shared between circuit clerks that are in this room and across the state. Well, why should all circuit clerks receive the same base pay? Because the people of the state of Missouri cannot afford to lose a third of our experienced circuit clerks every 4 years as we did in the 2019 to 2022 term. These leaders carried at the very least 4 years of experience out the door with them, and in most cases many, many more years than that. Salary is an important factor in the retention of these leaders. Circuit clerks' responsibilities can vary depending on regardless of the size of their staff or the classification of their county. And then circuit clerks' responsibilities require action at any time, any hour, any day. Circuit clerks are responsible for implementing all changes coming their way, regardless of the number of people they have to help them. I would suggest to you that we should not seek change for the sake of change, but that we should immediately seek change when it benefits the people we serve. I appreciate your time and your attention, and I would try to answer any questions.
Questions for the witness? Seeing none, thank you, sir. Next in support. Seeing none. Opposition, first witness. Anybody in opposition? Seeing none. Informational purposes only. Seeing none. Final comments.
We will get back with you on that substitute whenever we kind of settle on exactly where we want to be at. I appreciate your time.
Thank you. Now we will hear Senate Bill 1045, Senator Mosley. Senator, you may begin when you're ready.
Good afternoon, everyone. Thank you, Chair and Committee, for hearing my bill today. I am State Senator Angela Walton Mosley of Senatorial District 13. I am presenting SB 1045. This act moves elections from 4 streetlight maintenance district board members from the November general election to April general municipal election. The act modifies language to note that the election of new board members shall take place biannually as is currently provided by law. The act also provides that nominations shall be filed with the election authority rather than that they may be filed with the secretary of the board. This bill was heard last year as well and passed out the Senate. Kind of died on the House side. But if you have any questions, I'll ask. Yes, sir.
Could you please state why you think that the elections for streetlight maintenance district board members should be moved from November general election to the April general election? Maybe you said, but I missed it if you did.
Okay. Because that's when most of those type of elections are held is in April and not in November. That's the reason why, because it's a municipal election.
So do you think more people vote in April as opposed to November?
Not necessarily, but it'll be just going to coincide with all other municipal elections.
Okay. Any questions from the committee? Seeing none, first witness in support. Senator, he needs the microphone. Thank you.
Hello, thank you. I'm Elbert Walton. I served in the House for 14 years back in 78 to 92, I think it was. Anyhow, Senator Mosley introduced this bill after I met with Darrell Smith, who's the chairman of the Castle Point Streetlight District in St. Louis County. And we then went over some issues that they were having. And so he asked that Senator Mosley introduce that bill, and then I helped draft it based on my experience in the legislature. The reason for moving the elections from the November general election to the April general municipal election is the streetlight district is a subdivision similar to a school district, a fire district, a sewer district. All those elections are always held at what's called a general municipal election. The streetlight district being held in November is an anomaly, not normal, so therefore it was suggested that we move it to coincide with all these other political subdivisions. Other than that, the act simply makes sure that the transition takes place properly, because there's 3 board members and they're staggered every 2 years. So the rest of the bill is to make sure that that staggering takes place properly without any particular issues as to incumbent members of the board. And then Darrell Smith, who's the chairman, and I came up and spoke last year. He was a little ill and couldn't come today.
Okay. Any questions for the witness? Seeing none, thank you. Next witness in support.
Hello. Hi, Madam Chair, members of the committee. My name is Eric Fay. I'm the Democratic Director of Elections in St. Louis County, and we strongly support Senator Mosley's legislation in this regard. And just for a little background, I know this is a strange thing, streetlight maintenance districts. It's kind of an animal unique to St. Louis County, in that we have a significant portion of unincorporated territory that was developed prior to St. Louis County adopting planning and zoning in the mid-1960s for the unincorporated area. So we have these neighborhoods that do not have homeowners associations or subdivision indentures, but they require municipal services like streetlights. So what's happened, I think, Senator Gannon, you asked about voter turnout. So right now, although the elections are by state law required for November, they hardly ever have elections because the streetlight districts struggle so mightily with candidate filing. None of these districts have any full-time employees. It's usually the district secretary who is, elected to the board on a voluntary basis. The candidate filing happens irregularly at public libraries or things like that. And as a matter of fact, in 2016, absentee voting in St. Louis County was almost delayed because a streetlight district had to go to court to rectify errors in the candidate filing process. So this legislation would have the district board members file at the election authority, which would be a substantial improvement, and move it to the April general municipal election, where, as it was already stated, these other entities of similar situation already are put on the ballot. So overall, we feel this would be kind of a good government thing and strongly support Senator Mosley in her effort. Thank you.
Thank you. Any questions for the witness? Seeing none, thank you. Next, in support. Opposition. First witness. Seeing none, informational purposes only. Senator, do you have some closing comments?
Thank you for your time.
You're sure welcome. Okay, next we will be hearing Senate Bill 1389, I believe. No, excuse me. We will be hearing Senate Bill 1120. Okay, Senator Mosley. Okay, I didn't realize you had SJR84. Yes, while you're still there, let's let you present that bill. When you're ready, you may begin. I didn't see that.
Okay, thank you, committee, again for hearing my bill. Again, I am Senator Angela Walter Mosley, District 13. This is SJR84, current, and also, I don't know, where it is. I eventually will be doing a substitute for this because fiscal note and to match the bill on the House side. But current constitutional provisions exempt from property tax all real estate used as the homestead by a former prisoner of war who has a total service connected disability. This constitutional amendment, if approved by the voters, removes the requirement that the former prisoner of war have a total service of connected disability. This amendment also authorizes a property tax exemption for real property used as homestead by disabled veterans as defined in the amendment. The amount of the exemption shall equal, with the change, will be removing the 30 to 49% and changing it to 50% are entitled to 2,500 exemption. And I can take any questions.
Any questions for the bill handler? Seeing none, first witness in support. Seeing none, first witness in opposition. Seeing none, informational purposes only. Seeing none, Senator, do you have any closing comments?
Thank you for your time.
You're welcome. Okay, I think I'll get this right this time. Next, we will be hearing Senate Bill 1120. Senator Carter.
Good morning, Madam Chairwoman and committee members. I'm Senator Jill Carter, representing Southwest Missouri with the 32nd District. I don't know about you, but I've received a lot of frustrated phone calls with citizens who are trying to figure out why we would have eliminated the presidential preference primary. Senate Bill 1120 would reinstate the presidential preference primary election. This election would be held on the first Tuesday of March of each year in which the presidential election is held. This bill is very similar to the House bill that we heard in committee last year. After listening to concerns that were made from last year's clerks, we made one minor change to allow the clerks to have more time between presidential preference primary and the April elections. Instead of having it occur on the first Tuesday after the first Monday, we stated it shall occur on the first Tuesday. This small change will provide an extra 1 to 7 days depending on the calendar year. With that, if there's any questions, I'd be happy to answer them.
Do we have questions from the committee? Senator Crawford.
Hi, Senator. We've kind of had offline discussions about this. Why do you think we need to spend $6 or $7 million for something that means nothing?
So I did learn, Senator, that while the legislation doesn't say that the delegates are binding, the party rules do say that they are binding, and so that's my understanding.
I've been a delegate before, and I don't think that's correct.
Well, I'm happy to have that conversation with you. That's the information that I was given.
What will we have to do to make this binding? Actually binding.
I'm happy to have that conversation.
I would like to have that conversation too. I don't
Because
know.
that is my understanding, like I said, like we've discussed. And so if it isn't, that is something that needs addressed.
I do not believe that they're binding.
Okay.
That is binding. And I'll give you an example why. I was a delegate at one point in time, and I think Rick Santorum won the presidential preferential primary in Missouri. And by the time the caucus rolled around, he wasn't even in the race anymore. So, I mean, that's one example of. And I don't know if the Secretary of State, are you guys going to testify, or can you come up for informational purposes only so I can ask you a question?
I know it is
Thank
something
you.
I know it is something that they were concerned about. They had some involvement in this, so
I just want it to, if we're going to do it, I want it to count.
I understand.
And I don't think that it's binding.
We have had this conversation, so
Yeah.
happy to continue it.
Yeah, and I mean, people think their voice was taken away. I don't agree with that. We've always had caucuses. What I found fascinating, the most fascinating thing I found was that people had no idea that we've had caucuses forever, because I participated in. That is what I thought was the most fascinating part about this whole process. They acted like that was some brand new concept. Not the case. So
Well, they felt that they had that if they voted, it was taken care of.
right, and
You're
it was
right.
that was never the case. So
You're right.
okay,
Thank
all right,
you.
we'll continue this conversation.
appreciate that,
Thank you.
Senator.
So, Senator, when was the last time we had a presidential preference primary?
So this was a removal from a couple of years ago. It was actually the last presidential election was a presidential preference primary.
Okay.
That was removed in legislation, the election integrity election that we had a couple of years ago. And so I think that's where we're seeing all of this pushback from people that have been under the assumption that it was binding, that it was a presidential preference primary. And that's where we've gotten a lot of the phone calls, like I'm sure you guys have.
Okay. All right. First, any questions for the bill handler? Any more? Seeing none, first witness in support. That is A-OK.
I will slide.
I'm going to let my younger and better looking.
Representative Rick Stream is getting ready to testify here shortly, and he served 8 years in the House, and it's good to see you back in the House.
Thank you, Madam Chairman. It's good to see the members of this committee, a couple have left, who I actually served with. I've been gone almost 10 years now.
Yes,
so
yes.
Long time.
Okay, I just had to say that. Go ahead.
Thank you, Senator. Again, Eric Fay, Democratic Director of Elections in St. Louis County, with my counterpart, Rick Stream, the Republican Director. And we're testifying in support of Senator Carter's legislation today because so far it's better than the alternatives that have been presented, in that it does give us a little more time in between the April and March presidential primary elections. So in the past, we've always cautioned members of the General Assembly on scheduling two elections so close together, and we continue in that caution. We think ideally, if you wanted to alleviate this issue, you could possibly combine the March and April elections. I know there's been certain ideas floated about how to do that, potentially putting all of the presidential primary candidates on one ballot, that way alleviating the issue of multiple ballot styles at polling places and so forth. That's certainly something to consider. Another thing this committee should remember is that the RNC and DNC set the schedules for the states on when they can have their presidential primaries. And Senator Crawford, you brought up Rick Santorum. That was in 2012, and that was the trick bag Missouri got put in that year when our presidential primary was in February, but the national parties changed the calendar, and so our presidential primary couldn't count that year, and so the caucuses ruled that year. So Senator Carter is right that currently, at least the Democratic and Republican Party bylaws bind the delegates to the presidential preference primary, and I can't speak to whether or not you can bind them by state legislation. But again, we just want to testify in support of having as much time in between these two elections as possible, because it is really a tremendous effort to try to run two elections simultaneously. And I'll let Rick speak from there. Thank you.
Okay. Well, thank you again, Madam Chairman and members of the committee. It's good to be back. And I am testifying in favor of this bill because, as Eric said, it's better than what we've had to put up with certainly the last time. St. Louis County, as you probably know, has 1 million residents and 750,000 voters. So when we have to run two elections at the same time, it presents a lot of difficulty that we can get through. We have gotten through in the past, but if we have more time, as we do with this bill, then it makes it much easier to do it. So with that, I'll take any questions.
Any questions for the witness? Senator, you may.
I will.
Go ahead.
I don't really have a question, Senator. I kind of want to piggyback on what you said because this is my last session, and I've 14 years down here, and I will tell you are one of the finest people I had a pleasure of working with.
Yes.
And since I live on the other side of the state and our paths might not cross anymore, I might not have another opportunity to do that. So I am I'm grateful that you're over there and you're staying involved because you're a good person.
Well, thank you very much. I appreciate that.
Senator Rizzo, how will I fit Rick in the car on the way back? I don't know. Okay.
I think those of us that served with you in the House can certainly agree.
Well, thank you all very
Yes.
much. It was
Okay.
a pleasure for me to be down here.
Well,
A lot
good.
of great people.
I'm sure. Okay, next in support.
Yep.
Madam Chair, Senator Carter, thank you for allowing me to testify today. My name is Denise Lieberman. I'm the Director and General Counsel of the Missouri Voter Protection Coalition, which is Missouri's nonpartisan state voting rights table. We work to advance free, fair, and accessible elections for all Missourians. We're here today to testify in support of Senate Bill 1120. While our organization is nonpartisan and doesn't take a position on how political parties make their own determinations about their candidates, we do believe that the state can facilitate greater participation by all voters in Missouri. When we lost our presidential preference primaries several years ago in House Bill 1878, we really constricted opportunities for Missourians to be able to make their voices heard. And as last week's caucuses revealed, and this is not a nonpartisan issue, the process can be onerous, time-consuming, and very confusing for the average voter, dramatically limiting who is able to participate, plain and simple. As a result, only a small minority of citizens participate in the caucus system. And that's typically going to be party stalwarts, people who are very, very involved and perhaps representing kind of the most extreme positions of their political parties, meaning that the voices of the vast majority of everyday Missourians tends to go unheard in this process. And Senator Crawford, I think you stated earlier that many people didn't even know we had a caucus system in place prior to returning to it in 2022. And I think that speaks to why our members support us supporting this legislation, because we believe that democracy works better when Missourians' voices can be heard, resulting in a more inclusive, more representative, and more participatory process. Thank you.
One witness talked about when we last had the presidential preference primary. How many years have we had it going back?
Well, we did have it in 2020. I think it was 2012 was it 2012? I think when, 2016.
2016, okay. All right. Okay, thank you. Any questions for the witness? Seeing none, thank you. Next in support.
Madam Chair,
Yes.
Senator Carter, I'm Jeff Smith representing the ACLU of Missouri. The ACLU works in the courts, in the legislature, and in communities to defend and preserve the civil rights of Missourians. It is so nice to be here in your committee testifying in support of legislation, which is too rare. But we think this is a great bill for many of the previously stated reasons, that it is inclusive, it should encourage participation, it should in particular encourage participation among non-party affiliated voters. We want independents to be part of the process too, and this legislation will facilitate that. It will also facilitate engagement by people that have disabilities who can't make it out to a caucus, and provide opportunities for them and the elderly. So in sum, the primary system is more inclusive, it's more accessible, and we think more representative, will provide more representative results for the entire electorate than the current caucus system does, and we urge the committee to vote yes on this bill.
Any questions for the witness? Seeing none, next witness in support. Okay, in opposition. First witness in opposition. Informational purposes only.
Hi there, I'm Trish
Hi.
Vincent, the Deputy Secretary, and I brought an expert with me too, Scott Clark. He's the Deputy Chief of Staff. Scott's been involved, and he's actually attended national conventions. So, Senator Crawford, you're right, it'll cost about $8 million to have that. Our last one was about $7.5 million, so with inflation, standalone, and we do have to pay for that election. But I'm happy to answer any questions. I'm up here at your bequest.
Sorry to put you on the
No, that's
spot.
all right.
Do you know what year the presidential preferential started?
I don't. Scott, do you know?
I do. So for the longest time, we had caucuses until 1988. We had an individual from Missouri running for president, and the Missouri legislature put in a presidential preference primary that had an expiration date on it. Dick Gephardt was the candidate, and so Missouri held an early presidential preference primary. That campaign ended, and the legislation remained on the books until it expired. In '92, we had our next presidential election, In that year, there were caucuses in that year, and the caucuses were a little contentious. The Dole camp and the Kemp camp had a brawl, I think, in the Republican State Convention. That caused some issues, and so there was a thought that maybe, okay, that presidential preference primary in '88 wasn't so bad. Now, I was in the second grade in '92, so I wasn't there. In 1996, they had a caucus, I believe. In 1998, they passed the presidential preference primary that we used up until recently. In the first year, it was 2000. As has been said, in 2012, Missouri was in violation of the RNC rules, and I was on state committee at that time. And so in order for Missouri delegates to not be cut in half, the state party voted to change the rules. So even though the rules may say they're binding, rules can change, as the state committee proved in 2012. So in 2012, we held a presidential preference primary, but it was non-binding, and the caucuses were actually what were binding in 2012. In 2016, we returned back to a presidential preference primary system, and we had that in 2020 when 1878 removed it from the books. We did not have it this year.
So a couple follow-ups. Do you know why we had that whenever Gephardt was running?
So it's my understanding that they were trying to get him an early win, and so in order, Missouri obviously being a friendly state for him, to get him some delegates on the early end would hopefully help propel him.
So it really had nothing to do with how we were voting, or necessarily, in your opinion, would that be accurate?
Not to my knowledge. I'm explaining the history as it's been explained to me. I was 3.
I was older than that, but and so you said something else that piqued my interest. So you said the rules dictate whether the presidential preferential primary is binding or not. So currently it is, according to the rules, or it is not.
So this year we didn't have a presidential preference primary, so what is binding is the caucus vote.
So even though we have the presidential preferential primary, if the state party so determined, they could make it count or not count, depending on their rules. Is that right?
I would say yes. So the name is presidential preference.
Preferential, right.
Right?
Right.
So it's your preference. In New Hampshire, it's the New Hampshire primary, right? And so the delegates are bound. The New Hampshire process is a little bit different in that the candidates put forward a slate of delegates at the time of filing, where in Missouri, the delegates that represent the state are not chosen until later, right? And so the process is a different process if you look at it from that perspective. And so the candidate, quote unquote, binds their delegates in that they're putting forward the slate of delegates who are selected to go and represent in a presidential primary.
So what would we have to do in order to make certain that this is a real primary versus a preferential primary? What would that process look like? Or does that come from the national party? Or what I don't want to do is have an $8 million straw poll, because I think it's a waste of money and time. So any thoughts on that?
Well, you can bind, like Scott said, you can bind in law. It determines the party can bind them. And then having the primary, we just have to be careful with the rules of the RNC and DNC so that we actually do matter. I believe the House has a bill that puts us back in and actually binds the candidates. So, and then that way, it doesn't eliminate the caucus, however. We need to point out that the caucus would still continue.
And they always, they've been around for long before the president. They've been around forever.
So many times, these candidates file. I know that, just as a note, and here's $5,000 for the president to file with the party. I know that the Republican Party this year charged the candidates $50,000 to file with them. So, that's, something else to consider, what cost you want. But I remember that many times, like you said, that candidates had paid their fee, but by the time we got to the presidential preference primary, they weren't standing any longer. Just like I believe this year, Nikki Haley paid the $50,000. And of course, she has since resigned. Several candidates, actually, I think they had 4 candidates that paid the $50,000. Scott, did you have something to add?
I was going to say, so in New Hampshire, not that they're the best, but the delegates are selected by the nominee, right? So if you were to eliminate the caucus process, the only way we can select delegates to go and represent is through the caucus process, okay? Or the state committee would do all the picking and just at a state committee say these are the people who are going. That probably would not be the best way. But if the candidates were to put forward at the beginning, now I will tell you there will be people that are hesitant about that because there are some people who, you know, in October, they're for one candidate, and then by the time we get around to the election, well, their candidate's not in the race anymore, but they still want to go to a national convention. And so under the New Hampshire rules, those individuals do not get to participate because they were not on the original slate. So there is a give and take. There are trade-offs with the system. I'm like you. I was sitting in the crowd. I had people all around me who said, we've never done this before, and I gave them the legislative history on this as well. So we have always had caucuses. We have to have a way to select delegates in some fashion. The binding of them is a matter of preference under law.
I guess on the binding part, I guess, sorry to be ask so many questions, but I'm just trying to work through how we actually make this count if we're going to do it. If we bound the person who won the preferential primary, how do we fix that to where if they're out, I mean, does it move on down the line, or does the House bill address that? Do you know? Sorry to ask you off the top of your head.
I don't have it in front of me. I think that there are some perils, obviously, as we are talking through this, that if you bind it by the presidential primary, it would no longer be a preference. So you would have to do some definitions, I would think, in that. And then talking to the parties as well to make sure that they're on board. I mean, they do have to have rules. Do you want to do away with the caucus? Do they want to do away with the caucus? And again, we have New Hampshire that we can look at. But I think that those are all open-ended questions. Really, you know, the clerks in 1878 supported getting rid of the presidential preference primary. I think that we're adding a week is all, you know, here between the April and March. Do you understand what I mean? So it gives them a little bit more time, but it's still dicey with a lot of counties. I know that St. Louis County testified in support of it, but there are lots of clerks that still don't support. In my opinion, they've talked to me and talked to our office. So it's a complex issue, Senator.
I would have to agree, and I just think we need to be cautious. And I mean, I just think I think it's dumb to spend that much money for something that I'm not convinced is binding. So if you can convince me it is, it's a different story. And thank you for allowing me to put you on the spot and ask you to come up.
So I'll just ask you, since you're in support, do you think this is worth spending?
No.
Oh, informational purposes, okay.
Don't put us on the spot.
Yeah, okay. I was just curious as to if you thought it was worth the $8 million.
I think this is my personal opinion. That's
Yes.
taxpayer money.
Yes.
If it's not binding, that's $8 million that you all could virtually spend someplace else instead of on a beauty contest. So that's my opinion.
Yes.
That's
Do you
my
have any
opinion.
comments?
I'll put my personal opinion out. I attended my first caucus in 2004. I voted in the first presidential preference primary in that year as well. Caucus primary, either way, my vote counted because I showed up to either location.
Okay. Thank you. Thank you for being here today. Anybody else for informational purposes only? Seeing none, Senator, do you have any closing comments? Senator Carter.
Sorry, I was
It's okay.
This, if, as I understand it, Senator Crawford, if if that person is no longer in the election, the bid for president, then those delegates are then freed up. Those situations are addressed also in the party platform rules. So just for clarification there, but we can continue to have this conversation and try to bring reassurance to the concerns. Thank you so much.
Thank you, Senator. Thank you for being here today, and that concludes this hearing.